Knowledge is free for those who seek. This book is made available by Tashfin. Getting to Maybe. Chapter 1. You're not in Kansas anymore. A place where knowing the material is not enough. Every law student craves the answers to a few big questions. Can I handle the pressure? Will I make the law review? What kind of job can I get when I graduate? Does law school leave room for romance? We suspect, however, that one question burns deepest in the hearts of all, but the few students at the top of every class. How come student X did better on, say, the torts exam than I did, even though I studied twice as hard and knew the material much better than she did? The point of this book is to provide you with an answer to that question from a law professor's perspective, a perspective we think you'll find useful, since it is invariably a professor who decides whether to give you or student X the higher grade. But we want to begin the book by considering answers our students sometimes give to this burning question, since we think those answers reveal some common misunderstandings about law exams. A. Student X had a copy of a torts outline put together by the guy who booked last year's class and who is now the professor's research assistant. B. Student X ignored everything the professor said and read Glennon or Emanuel's the night before the exam. C. Student X is just smarter than the rest of us. We hear these answers or slight variations on them all the time from students disappointed with their law school grades. And as usual, our students are on to something, for there's a grain of truth in each answer. It can help your examination performance to work with a good outline for the course. It might also help to step back from your own materials, your class notes and case briefs and outlines to get a fresh overview from a high-quality commercial study aid. And of course, it never hurts to be really smart. But these answers also share a common yet misleading assumption about law exams, namely, that the key to excelling lies in what you know coming into the exam. On this view, if you could only get your hands on the definitive outline or the right hornbook, and if only you were smart enough to keep it all in your head for the 3 to 4 hour ordeal, you'd be on your way to law review and legal stardom in nothing flat. In point of fact, you do need to know the material, the seemingly endless collection of cases, rules, policies, and theories examined in each of your courses, in order to excel in law school. But the rub is that knowing the material is only a starting point, for the typical law exam doesn't simply test your ability to recall or even to understand really well the many things you learned from the course in question. Rather, the typical exam tests your ability to use the material you've learned and to apply it to problems you've never seen before. To get a sense of what we mean, forget about law for a moment. Assume instead that you are taking a graduate course in engineering, and that you have spent the semester studying the properties of various building materials and a host of theories of design. You have dedicated virtually every waking moment to this course. You have read and reread every assignment and taken copious notes. You have come to each class session meticulously well prepared. You have taken down almost every word the instructor has uttered. You have saved and annotated every handout. And during the 2 weeks just before the final exam, you have organized and reorganized and outlined and committed everything to memory with such success that, in the highly unlikely event that someone besides a classmate were to ask you to explain the differing properties of, say, plastic vs. glass, you could quickly rattle off everything that could possibly be said on the subject. You enter the room for the final examination, and the proctor presents you with a large box containing a seemingly random assortment of materials of the sort studied in the course. On the blackboard, the proctor writes the following instructions. Using the materials in the box before you, design and construct a widget according to the principles we studied in the course. Unlike law students, engineering students know exactly what widgets look like. Confronted with this daunting task, you would no doubt find the massive information you have mastered in preparation for the exam helpful, indeed crucial. But you would obviously be making a serious mistake if you left the contents of the box untouched and proceeded instead to compose an essay on the fundamentals of materials and design and to submit it for the grade. The point of the exercise is not, after all, to regurgitate what you know, but to use what you know on what you happen to find inside the box. Perhaps the most important lesson we can teach you about law exams is that each question you will encounter is a lot like the engineering student's box. It's what you do with what you find inside the question that counts the most. In all likelihood, what distinguished student X's performance from everybody else's on that torts exam was less what she knew coming into the exam, let alone which outline she had, or which hornbook she studied, than what she did with the questions she encountered on the exam itself. And the intellectual skills that enabled her to handle the questions so well can be learned and developed by virtually any student who is smart enough to get into law school and diligent enough to put in the time. But truth be told, we legal educators generally don't do a very good job of teaching exam skills, at least not directly. We focus instead on the intricacies of legal reasoning and argument, and on the policies and theories that organize and complicate each area of the law, and we seldom explore in any depth the connection between those lessons and the challenge of law exam taking. So even the most enterprising student has little choice but to draw upon sources that turn out to be less than fully reliable, for it's almost impossible to master law school exam taking by relying on undergraduate habits, tips from fellow students, or even the Socratic dialogue in the classroom. In this book, we'll tell you why those experiences may send the wrong messages, and we'll provide you with someplace else to turn. Some lessons you may need to unlearn. Lesson #7 Undergraduate Exams and the Information Dump. Consider, first, the exam-taking habits pushed on you in undergraduate school and even before that. College-level testing often involves a demonstration of student knowledge. Who was William the Conqueror, and what country did he invade and when? How many hydrogen atoms make up a water molecule? Such questions conform to a vision of memorize and regurgitate learning, and to many students, law school initially appears to be the ideal spot for raising this kind of testing to new heights. How many days do I have to file that appeal? How many witnesses must there be for the will to be valid? Given the gargantuan number of laws on the books, law professors could easily give closed-book exams filled to the brim with nothing but questions calling for esoteric knowledge of memorized legal intricacies. But we don't. It's true that failing to grasp the basic points of your substantive courses will prove fatal to your exam performance. In constitutional law, for example, you need to know that Marbury v. Madison established our tradition in which the federal courts have the power to invalidate acts of Congress in the name of the Constitution. Going beyond the basics, however, to attempt to memorize verbatim every little rule and sub-rule you encountered during a course is unlikely to be particularly helpful, because law school exams are about much more than just accumulated knowledge. Indeed, testing principally for such knowledge would be foolish. As an attorney, you can almost always look it up if you need to. In fact, on most occasions, it would be irresponsible not to look it up, even if you were absolutely positive you remembered it. Besides, to invoke once again our engineering exam analogy, a client seeking a lawyer's advice doesn't need someone who can recite legal rules from memory. Rather, she needs someone who will use all that knowledge to help her solve her box of problems. Exam-taking skills developed before law school, however, cause many students to persist in treating our questions as if they called for a memorized answer. To see what we mean, let's work through a concrete example. Assume that you are attempting to answer an exam question on that favorite topic from first-year contracts, the battle of the forms. Say the first thing you notice about the question is that the transaction at issue involves the sale of a customer list from an established firm to a startup. Oh, you think, is that a sale of goods? It's a sale, sure enough. But isn't a customer list too intangible to be a good within the meaning of the UCCJ? Then you see that the selling firm's offer requires payment upon delivery of the list, but the buyer's response promises to make payment within 30 days. Oh no, you think. Noda, I've got to figure out whether the code or the common law applies. If this is a sale of goods, then there may be a contract under 207 in spite of the differing terms. But if it's not a code transaction, then the differing terms will kill the deal under the common law rule that a valid acceptance must form a mirror image of the offer. The hypothetical draws to a close. with the selling firm tendering the customer list and demanding immediate payment, the buying firm insisting on its own 30-day term, and the seller seeking your legal advice regarding its rights in the dispute. Yikes, you think. If the case is governed by the common law, maybe the seller accepted the buyer's terms by performance, that is, by tendering the list after the buyer fired the last shot in the exchange of documents. On the other hand, if UCC 2207 governs, then everything may turn on whether the difference between the conflicting terms is material. A 30-day difference in a payment schedule doesn't seem like that big a deal. But if the seller sold the list because of cash flow needs, maybe it is. But wait, isn't 2207 supposed to deal with cases involving parties who do business by exchanging preprinted forms replete with self-serving boilerplate? Does it make any difference that the parties here don't seem to be using any forms at all? As we will shortly explain, the point of an exam question like this one is to get the student to identify each of the ambiguities noted in the parentheticals, and to analyze the difference the resolution of those ambiguities might make to the rights and obligations of the respective parties. But in the face of exam pressure, many students respond by ignoring the ambiguities, indeed, by ignoring the facts stated in the question altogether, and treating the problem as an invitation to begin writing everything they know about the battle of the forms. We refer to an answer of this kind as an information dump. The student interprets the question actually asked involving multiple issues, complex facts, and competing equities as an opportunity to do what he used to do, and no doubt did very well in college. Write an essay designed to persuade the grader that he really understands the battle of the forms. But what he has done instead is persuaded the grader that he couldn't, or perhaps that he just didn't want to grapple with the vexing problems presented in the question he was asked. And like the engineering student who writes an essay rather than building a widget out of the box of materials, chances are he won't be very happy with the grade he gets as a result. Lesson 2: Sorting through the law school rumor mill. To be sure, students begin to hear that law exams are different from almost the moment they set foot on their law school campus. As with most rumor mills, however, there's a good bit of misleading advice lurking within the conventional wisdom imparted by second and third-year students. Imagine a rookie basketball player whose teammates' advice on covering a superstar is force him left. The rookie enters the game and invites the star to drive left. The star promptly does so, putting the ball in the basket with a beautiful left-handed shot. During the next timeout, the rookie presses his teammate. "I thought you told me to force him left." Without batting an eyelash, the teammate responds, "You should see what happens when he goes right." Law students who trade the information dump for the helpful hints from their classmates and from upper-level students may have a similarly unsettling experience. "You told me to spot the issues." A student was recently overheard complaining to a colleague shortly after the first semester grades were released, and the professor admitted that I saw most of them. "But I only got a C+ on the exam." The predictable response. You should see what you'd get if you didn't spot the issues. Like knowing the material, the ability to spot the issues is crucial to a successful exam performance. But knowing the material, issue spotting is nowhere near enough. Recall for a moment our hypothetical battle of the forms question. An answer that reads something like the following would almost surely get a passing grade at virtually any law school. The first thing we have to decide is whether the sale of a customer list is a sale of goods under the UCC. If it is, then the next issue is whether the buyer's 30-day term is a material alteration of seller's offer. But if it's not a sale of goods, then the issue is whether the seller accepted the buyer's terms by performance. The student has indeed spotted the issues and would no doubt get credit for that. But like the student who dumps information rather than using it, the student who merely spots the issues without going on to explain why they are issues, what difference they make, and the arguments for resolving them one way or another, will at best end up somewhere in the undistinguished middle of the class. In Part Roman 2 of the book, we will explore in great length what you should do with issues once you spot them. There are two other exam-taking strategies frequently promoted by well-meaning fellow students that may be equally misleading to a beginner. First, there is the suggestion that all you need to do on the final is to show the professor that you've grasped the fundamentals of the course. This approach does have one thing going for it. You can organize and draft your answers well in advance of the exam, and you won't have to waste any time during the exam period itself reading, let alone thinking about the professor's questions. The downside, of course, is that this is simply a variation on the information dump we talked about earlier, except this kind of undifferentiated dump is likely to get you an even lower grade. Thus, the student who responds to our hypothetical question by writing everything she knows about the Battle of the Forms might get at least some credit for signaling to the professor that she recognizes the basic legal problem that the question addresses. By contrast, the student who responds by attempting to demonstrate that she's grasped the fundamentals of the entire contracts course is likely to lead the grader to the conclusion that she didn't have the faintest idea what the question was about. The other strategy you are likely to hear about from your classmates is the so-called Iraq method. The idea here is that exam taking can be reduced to 4 simple steps. I spot the issue. Roman 2 cite the rule that resolves the issue. Roman 3 apply the rule to the facts presented. And Roman 4 offer a conclusion that answers the question. We will discuss the dangers of Iraq at greater length later in the book. But for now, suffice it to say that attempting to reduce law exam taking to 4 simple steps is a lot like attempting to reduce guitar playing to 4 simple chords. It's not a bad way to start, but until you get well beyond it, no one is going to mistake you for B.B. King. Indeed, you could write a book about the many important exam-taking skills that simply cannot be captured in Iraq or in any other one-size-fits-all formula. We have, and you're reading it. Lesson FT3, The Dark Side of the Socratic Method. The Rulebook vs. the Loose Cannon. Perhaps the cruelest aspect of the law school exam process is visited upon those of you who look for lessons in the place you legitimately should expect to find them inside the law school classroom. Many students enter law school expecting to memorize a massive quantity of legal rules for regurgitation on command, much in the manner that the interns and residents on the popular television series are asked to rattle off the names of 1,000,001 body parts, symptoms, and diseases while making rounds with their senior colleagues. We have no idea whether accurately captures the rigors of medical training. But the law student who anticipates a memorize and regurgitate model of education is in for some big surprises at most American law schools. One surprise is that most of the rules you are expected to master are buried in the text of judicial opinions. In spite of the fact that you're paying thousands of dollars a year to have a faculty of experts teach you the law, it turns out that your professors expect you to figure out the rules often referred to as case holdings on your own. What's worse, you never seem to get them right. Does the holding of Romer v. Evans, 517 U.S., 620 1996, apply to all laws that discriminate against homosexuals, or only to those that prevent them from securing the same protection others are afforded by civil rights statutes? Does the holding Oy Hawkins v. McGee, 84 NH, 114, 146A, 641 1929, govern damages for every breach of contract, or for broken promises in the context of medical treatment gone awry, or just for hairy hands? Nor can you find the solace of certainty in the statutory supplement. It may seem that at least these are rules you don't have to figure out on your own. After all, they are written down in black and white. But before you've even had time to breathe a sigh of relief, you discover that it is just as difficult to determine the meaning of a statute or a provision from the Constitution or a section from the Restatement of Torts as it is to figure out the holding of a case. When you offer an interpretation based on the plain meaning of the rule, "no vehicles permitted in the park" means all vehicles, period, the professor is bound to respond with a series of perplexing questions. Is the meaning really so plain? Are tricycles among the vehicles to which the rule refers? What did the drafters intend? Were they even thinking about tricycles? What policies were the drafters trying to further? Do tricycles produce the noise pollution, and risks to pedestrians we associate with automobile traffic. Worse still, if you came to law school expecting simply to memorize and regurgitate rules, the biggest surprise may be that determining the meaning of the rule is just the starting point in legal analysis. A lot of time is also spent applying the rule to the facts, a task that turns out to be every bit as daunting as determining the meaning of the rule itself. Was the uncle's promise to give his nephew a large sum of money if the latter refrained from smoking an offer proposing a bargain? Or was it merely a conditional promise to make a gift? If the host invites you, but not your boyfriend, to a party, and your boyfriend shows up anyway, injuring himself on his way in through an unlocked back door, is he considered a licensee or a trespasser? A significant part of what law professors teach and test is designed to help you learn to cope with these kinds of questions. But many students find classroom discussion maddening, because it's a rare professor who will stop to highlight the difference between good and bad efforts at rule identification or application. What happens next is at the root of more exam disappointment than almost anything else we can describe. Students grow increasingly frustrated by the lack of hard and fast answers emerging from the so-called Socratic classroom, and as a result, many are drawn toward one or the other of two highly simplified approaches to legal analysis and exam taking. We'll refer to those approaches here as the rulebook account and the judge as loose cannon. Simply put, the rulebook account is shorthand for the belief that once you know the rule decides the case. On this view, legal reasoning is one part memorization and one part logic. The job of the judge, or the laver who appears before her, or the student on the exam, is simply to apply the governing rule to the facts at hand and to announce the result. To form a contract, the terms of the acceptance must be the mirror image of those in the offer. In this case, the seller's offer called for immediate payment, and the buyer's would be acceptance stipulated payment in 30 days. Therefore, there is no contract. Next case, please. With the possible exception of law enforcement personnel and others who've had frequent contact with the legal system, most non-lawyers, and thus most beginning law students, seem to think that the law works in this way, at least when it's working properly. As a consequence, the experience of the first semester of law school can come as quite a shock, since it typically consists of the study of case after case in which the rules, the facts, and the connection between the two can be argued in more than one way. Recall, for example, all of the ambiguities and complexities in our battle of the forms hypothetical ambiguities and complexities that the simple syllogism at the end of the last paragraph completely glossed over. Students respond to this gestalt shift in different ways. One approach is to cling to the rulebook account. We suspect this is an instinctive reaction because the rules offer a lifeboat of seeming certainty in the raging sea of ambiguity explored in the law school classroom. You know you're not swimming, but at least you won't drown. Some students may even begin to think of the professor as a heretic and the Socratic inquiry as a form of religious persecution. Paradoxically, this stance often involves a firmer resolve and a strengthened belief in the importance of the rules. Okay, they think. Maybe some smarty pants, overeducated preppy law professor can score picky debating points on helpless neophyte law students. But rules just have to decide cases, since the only other alternative is that judges are free to do whatever they want and to run utterly amok. Yet another group of students comes to agree with this last point, i.e., that the only alternative to rules deciding cases is judges doing whatever they want. But from that premise, they are pulled toward a more cynical conclusion. Having studied case after case in which the rules could easily lead to more than one result, these students embrace the approach we refer to as the judge as loose cannon, that judges decide cases on the basis of values or politics or policy, or what they had for breakfast, or some combination of such factors having nothing whatsoever to do with legal rules. In point of fact, as our students line up on each side of this divide, they are in their own way reenacting a long-standing debate in American law, a debate the roots of which go back at least as far as the beginning of this century. Fortunately for you and for us as well. We don't have to rehearse or resolve the debate between formalism and legal realism here. Instead, what we want to do is to show you how the extremely oversimplified versions of these positions that beginners frequently espouse, that is, naive formalism, the rulebook account, and vulgar realism, the judge as loose cannon, can undermine your capacity to make persuasive legal arguments, and with it, your ability to excel on law school exams. In a nutshell, the students who embrace the rulebook account tend to write exams that substitute rule regurgitation for reasoning and analysis. On the upside, they frequently come to the exam having mastered, or even memorized, every little rule, sub-rule, and exception that was covered in the course, and, just in case, some that the professor never even got to. But the trouble begins when they read the first question and encounter the sort of ambiguity that is typically present on a law exam. Perhaps it is a case in which more than one rule might govern, e.g., a riparian property rights case that would come out different ways under the respective doctrines of reasonable use and prior appropriation. Or perhaps it is a case in which a single rule clearly governs, but the rule might be interpreted in one of two ways, e.g., a proximate cause problem that might be decided one way by Cardozo and another way by Andrews. Or perhaps it is a case in which the rule and its meaning seem fairly clear, but the facts might be interpreted in more than one way, e.g., a transaction, HKE, the uncle's promise to give his nephew $5,000. If the latter gives up smoking, that might fairly be characterized either as an offer proposing a bargain or as a conditional promise to make a gift. Confronted with ambiguities like these, our rulebook devotee is stymied because there is no rule telling him how to resolve them. There is no small irony here. Since law professors almost invariably try to test what they teach, the chances are that the student's instructor spent substantial class time working through these very problems, or problems quite key them, attempting to demonstrate through lecture and/or Socratic discussion that there was more than one way of looking at each of them. Yet our student may well have stopped taking notes at the time because he was waiting patiently through all the argument and counterargument for a punchline, waiting, that is, for a rule to come to the rescue with some definitive resolution. As a result, when he encounters such a problem on the final, he may well experience a sense that he is the victim of a malicious bait and switch. After spending the semester teaching the class rule after rule after rule, how could the professor have decided to test the very questions for which the rules don't provide clear winners and losers? Unsure of how to deal with problems that the law doesn't seem to solve, the rulebook devotee may retreat to his natural habitat and draft answers designed to demonstrate his mastery of the rules, all the while avoiding the ambiguities that would arise in attempting to apply them to the facts presented in the question. Yet the point of the typical law exam is precisely to see whether students can identify, analyze, and argue thoughtfully about such ambiguities. And so an answer that has simply wished them all away is unlikely to distinguish itself. By contrast, a student who embraces the judge as loose cannon approach tends to write exam answers that discuss everything but the rules. Once she picks up on what she sees as the principal lesson of the Socratic method, that rules don't decide cases because there is always another way of looking at things, she stops taking notes every time a legal rule is discussed. What's the point in focusing on that, she thinks, since the decision is always based on something else? That something else may vary from professor to professor, and even from case to case. Sometimes it seems to be policy, e.g., the security of transactions in contras or loss spreading in torts. Sometimes it's the equities presented by the facts, e.g., the vulnerability of the impoverished tenant at the hands of the wealthy absentee landlord. Sometimes it is the judge's values when the professor agrees with her, or her politics when he doesn't. Since in the view of such a student, these extra legal considerations are what really drive judicial decisions, she sees no need to spend precious study time mastering the intricacies of the seemingly pointless array of rules. Come the final exam, she may well be in for a complete disaster. For one thing, since most exam questions test the student's ability to use legal rules to make arguments, it is now our unsuspecting student who has become the loose cannon, entering the battle virtually unarmed. A central task of lawyering is to translate the facts policies, equities, and values that support her client's case into the language of the law, e.g., the landlord breached the warranty of habitability, and therefore the tenant should be able to withhold her rent. And you simply can't do this unless and until you develop a facility with the rules that form the basic rhetoric of legal argument. For another thing, when it comes to a task that separates the best answers from the merely mediocre, i.e., dealing with the ambiguities that complicate the legal analysis of the question, the loose cannon student may not even be able to identify those ambiguities, since she has not taken the rules seriously enough to see how they might lead in several directions. She is unlikely, for example, to figure out that the uncle's promise could be interpreted as proposing either a bargain or a conditional gift, unless she understands the legal requirement of consideration. Of course, many students find themselves drawn simultaneously in both directions. Some conclude that cross-dressing may be the safest course and offer randomly alternating approaches consciously or unconsciously in the hope that something they say will please the grader. Others try to embrace both approaches at the same time. Like the atheist who hedges his bets by sending the children to church, the rulebook proponent may conclude an extended regurgitation of rules with an abrupt loose cannon appeal. Of course, it depends on your politics, he writes. I champion the weak against the strong just like the professor. So I think the court should rule in favor of the family farmer and against the coal company. But a more conservative judge might come out the other way. Ironically, in the end, the two approaches leave the student in much the same sorry fix. The rulebook devotee may see the ambiguities on the exam, but he ignores them because he thinks the law requires an answer, and he doesn't have one. The loose cannon cannot even spot the ambiguities, for she has ignored the rules because they only lead to ambiguities. But like Dorothy in The Wizard of Oz, they've each had the ruby slippers all along, for if they had learned to embrace the ambiguities they have been so busy ignoring and denying, they'd be on their way to law review. We said at the beginning of the chapter that the most important lesson we could teach you about law exams is that it's what you do with what you find inside the question that counts the most. The second most important lesson should be apparent from the foregoing discussion. What you will find inside the typical law exam question is ambiguity, and we think that learning to live with it, indeed, learning to search it out and exploit it, is the key to doing well on law school exams. In the rest of the book, we will attempt to translate these basic lessons into a blueprint for concrete action as you pursue your legal studies and prepare for and take exams. Part I of the book, Issues in Living Color, will help you learn the specific ways in which law professors use ambiguity to create issues on law exams. We have designed Part II, Strategies for Issue Spotting, Analysis, and Argument, to help you learn how to recognize those issues and how to deal with them as you draft your exam answers. In Part III, Test-Taking Tips, we offer more generalized advice on exam preparation and exam writing, and we also address some frequently asked questions from our students. Finally, the book ends with a series of sample exam questions and answers from constitutional law, contracts, property, and torts. The idea here is to provide you with an opportunity to see our advice put into an action. Our aim is to clarify, not simplify, the examination process, and accordingly this book will require sustained effort on your part. We are confident, however, that there will be a big payoff in terms of improved academic performance. As for the romance part, you're on your own.